Excellent. Thank you, whoever did that. The recording. We are recording, Judge Hedrick, so just so you know, if that's okay with you.
It is. I'll try to watch my language.
Actually,
I was sort of raised by wolves. My daddy was a very working class factory guy, and I was the tomboy of the family. So I hung out with my dad and his buddies a lot. So my vocabulary is a little descriptive sometimes, but I'll try to behave.
Okay. Well, in case I get you going, I apologize. I worked for 2 summers on the shipping docks of a manufacturing company here in my hometown. I happened to be in my hometown visiting my father, and I learned all sorts of exciting things on that. All right. Well, I think we're close to noonish, and I'd like to welcome everybody to the Legal Women Voters Hot Topics for September. So I think you all know that in the first Friday of every month through this year, from August actually, through I think June. I think we take July off, at least July off. Sometimes, we fudge it from time to time, but certainly through the coming year, every first Friday of the month, we will be having a hot topic. So just to let you know that in October, our first Friday will be October 6th. And we will be having a talk by Reverend Stacy Rector, who is the executive director for Tennesseans for Alternatives to the Death Penalty. So that will be October 6th. That's the first Friday of October. And we hope to see you all there. But today we are going to be joined by Judge Andra Hedrick. And I just want you all to know that I met Judge Hedrick outside my polling place in 2022. And as you all may know, I'm kind of good, or I kind of like engaging folk, and then like swapping stories and whatever. And it turns out Judge Hedrick is right up there. She was fantastic. So I could not wait to share her with you all. And in particular with the most exciting concept, which is probate. And I just thought, well, what do you mean by probate? And it turns out Judge Hedrick can make probate absolutely fantastically interesting. So let me give you a little background. A whole lot of people in Middle Tennessee don't have any idea how probate works. And that's when, someone passes and you end up, I mean, probably Judge Hedrick knows this a lot better, but if you end up in her court, you're ending up because of whatever reason. And a lot of people don't know about it. So one of the things that I realized when I spoke with her outside my polling place last 2022 is that one of the things she's dedicated to is in educating everyone about what probate is and what her court does. So I thought, what better way to do that than to bring her to the hot topics? And since we record things and we put it on our website, possibly she can use this, as well as the way she does all sorts of other things that she was telling me about educating, including talking to crazy ladies like me outside of her polling place. So let me give you a little bit of a background on Judge Hedrick. So she was a full-time probate lawyer, and she had more than 23 years of experience and has written the book literally on Tennessee probate law with a co-author, Jeffrey Mobley. So she graduated from Indiana University a while back, and her doctorate degree from Memphis also a while back. And she was, we don't want to make that all, a while back. And so she was involved in the probate in Middle Tennessee for a long time, and then she ran for judge last year, and she got in, and she's here to talk with us today. So with all of that, Judge Hedrick, I'd like to let you begin.
All right. And thank you so much for letting me be here. we were talking earlier, and to be honest with you, anytime someone is willing to listen to me talk about probate, it just makes me incredibly happy because it's what I do and what I love, and what gets me excited, to wake up every day. Little bit more history on the how did we get here. Sometimes elected positions attract folks who are very heavily into politics and aspire to political office during their adult lives. And that's really probably not me. I'm just a nerdy probate lawyer who got lucky to find an area of law that I love and people that I love doing it with. I was kind of started in this working even as a law student for the probate judge in Memphis, and watching lawyers do what they do every day, and then thinking, well, wait a minute, that looks sort of fun. And that looks like something I could probably do. So that's kind of how I started. And then I got the ultimate luck out of the world, which was when entering private practice, I had Gullett, Sanford, Robinson, and Martin here in Nashville hire me. I literally sent one letter to one firm, and I picked the firm that I knew was so deeply entrenched in probate through Jack Robinson Sr. and Jeff Mobley that I just wanted to be with the guys who were considered the best in the business. And I'll be damned if I didn't get lucky and have them want me to come along for the ride. So a lot of people have paved the way to let me do what I do. The most recent of which, of course, is Judge Randy Kennedy, who had my position for 19 years and went out with a bang in his retirement and left an open spot for us to fight over a little bit. And, it's only the probate court that would have ever brought me out of law firm life into the public sector, because it is what I like to do, and it's an opportunity to do it every day where I like to do it. So I'm just very grateful that I got that opportunity. But I was not a natural campaigner. I'm really just kind of a shy nerd, and but had to certainly learn about campaigning and talking to people and being at the polls and approaching random strangers, like I did at Sylvan Park that day, to try to talk them out of whatever it is they were planning to do that day. And so I'm just glad we met, glad we got an opportunity to learn about each other. I do want to acknowledge on this call is Carol Busey, who was also one of the first people I met in moving to Nashville all those years ago, the historian for Metro Nashville, knows everything about history you could ever want to know, and happened to be married to one of my law partners, Ray Busey, at Gullett Sanford. But I digress. Let's talk about probate court. We in Davidson County have one dedicated probate court that has probate designation, and that happens to be my court, which is the Seventh Circuit Court. We're located in the historic Metro Courthouse, so that's the one downtown, not the Birch Building, with the criminal law people, but it's the one downtown with the mayor's office, the Metro Council, and the state trial courts. So that would be Circuit Court and Chancery Court. We do the oddest things, and we do things that other courts don't do. Let's just talk about sort of categorically some of the things that we see. We do conservatorships, okay? Conservatorships are cases where you have someone who's alive, but they're alleged to be suffering from a disability and they can't make legal decisions for themselves. So the loved ones, whether they're family, friend, or the state of Tennessee, come to court and ask for someone to be appointed to make legal decisions for them. Oftentimes they're age-related kind of illnesses. Sometimes it's an accident, a catastrophic brain injury because you had a unexpected thing happen in your life. Sometimes it's straight up mental illness, bipolar, schizophrenia, all those things that just seem to be plaguing society. And other times it's sort of there are some other reasons, but those are the ones that we see most often. I do want to acknowledge and give a shout out and thank you and a recognition to Judge Amanda McClendon, who is probably hiding behind her screen, but I saw her on the list. She is our second circuit court judge, one of my colleagues here in the building with me, one floor down, and she does conservatorships as well. And you might wonder, well, why does that even happen? Because I thought that's a probate issue. Well, it is a probate issue, but in Davidson County, we only have one court designated with probate jurisdiction versus Memphis Shelby County, who has 2 full-time probate judges, a smaller number of cases in total, and a population that doesn't quite keep up with Nashville, Davidson County. So what that means is there are not enough hours in the day or human beings that work in my court that we could possibly keep up with all of the conservatorship cases we have. So enter the cavalry, which includes Judge Amanda McClendon, who in Second Circuit is fantastic in helping us with our caseload. And she takes all of the emergency conservatorships because those you have to act on very quickly. There's, in an emergency conservatorship, someone is usually in danger or in a health care facility that needs to get them transferred to a step-down facility or a group home or somewhere that's more appropriate for their care. So they will petition the court to have someone appointed for decision-making. And Judge McClendon has so many of those cases. It boggles the mind. And you might ask, well, why does Davidson County get all these cases? Is it just population? Well, it's partly that. But it's also the fact that we have some of the best healthcare facilities in the state. So you have folks who come into our hospitals because that's where the doctors are that they need. When they are here, the conservatorship needs to be brought here because that's where they physically are. They may or may not have a home to return to elsewhere. But when they get released from the facility and go to an assisted living or a nursing home or a group home or whatever the housing arrangement is, oftentimes they're even going out of county at that point. But we still keep the conservatorship here. The reason being is that oftentimes they don't have any money. They can't afford to start over again. We take the view that it's our responsibility to still look after them, still manage the handling of their finances. We obviously can't look after every single decision that is made, but what we can do is require accountability in terms of filing an inventory of what the conservator has been able to access, filing a property management plan, which is a written statement of what are the expenses, what's the income, what's the assets, and how do I propose to spend it. Okay, so it's a budget, for lack of a better term. And then an accounting, which is the real oversight, which allows us to track how are they spending someone else's money. And it's a very sticky wicket, right? Because without that supervision, it would be very easy to kind of run amok, help yourself, not spend it appropriately. And I'm sure in your lives and your families, you've maybe seen some examples of that. So although we have a lot of chickens to watch over, we do our best to try to keep it on the straight and narrow. How we do that is with a lot of help internally from staff. The handout that you're welcome to share with the membership tells you that we do have a little larger staff than a lot of the courts, and that's simply because of the volume of cases we get. We have, for example, a probate master who is a lawyer who works for me. She conducts hearings of her own. She reviews every inventory, property management plan, and accounting. She will do what's called a show cause hearing. If someone fails to file something on time, she calls them out for it. She will require them to be bonded if there's money. Bonding is just simply, it's not like a criminal bond. It's like an insurance policy that you have to go get to make sure you're credit worthy. And if the conservatorship suffers a loss because the conservator steals money, it's a way to get the money paid back. Okay, so my probate master really manages and handles all of that until she sees something that rises to the level that she refers it to me, and I have to do something a little more drastic, like remove a conservator or enter a judgment against them. We team up in handling those cases together. All right. I also have, and you'll see on this paper, I have another attorney that works for me that sits as special master on estates. I have a paralegal, Deanna Alexander, who is, she's on our Zoom today, who is honestly, the person in this office who keeps the glue together as far as making sure we stay on schedule. I sign all the orders I need to sign. She revises orders when they need changes because they're not accurate. From, the lawyers sometimes send us in orders that don't really accurately reflect what happened. So she keeps notes, we check them, and then we correct them if necessary. Kitty Lammers is on here. She's my assistant. She does all the scheduling of specialty items that don't go on the regular docket. We also have a court officer that keeps us safe, Pat Saltkill. I think he's probably watching with Kitty right now. Yeah, so we're a pretty big team of people, but we handle a large number of cases. We did talk about well, and when I say large, like what are we really talking about here? Breaking down the numbers, I was looking at our August 1st book of business, right? How many cases are technically open with the court that have something pending in them? I have 5,268 cases. That kind of boggles the mind, right? So a lot of those cases don't have current activity, but they're open because somebody's alive. We talked about the conservatorships. When a conservatorship opens, it doesn't typically end until the person dies. That could be 10 years, 15, 20 years, right? Or it could be when their condition improves such that they need to be released from their conservatorship. And that happens. It's rare, but it does happen. So that's why you see all these cases building up. We live longer. Our population is growing. And so those cases have to still exist under our supervision as long as the person is under conservatorship. But by far, the most common new case we see is an estate administration. So an estate is where someone has died. Okay. And so on the paper that we shared, you'll see where it says estate administration with a will. And right now we have almost 1,900 of those cases open. Just 1,900. That means someone has died. They owned probate property at the time of death. I'm going to get back to that in just a second. But it means they had a will. And if they had a will and it meets the requirements to be probated in Tennessee, then that means the personal representative appointed in the case basically uses that will as their playbook as to how they need to distribute the property. Okay, because that means the deceased person has made those decisions for themselves, written it down, put it on paper. Here's my instructions. Here's what you need to do when I die. Now, the other group of cases we have that are deceased individuals are estate administration without a will. And the buzzword there is intestate. Okay, so if you ever read or hear anybody talking about, oh, well, that's intestacy or that's an intestate estate, that's just a trigger word that means there's not a will. Okay, so if there's not a will, the state of Tennessee writes your will for you, and they pick who gets your stuff with a pecking order based on the type of family relationship you have. And this is a whole other law school class really to go through what that pecking order is. But bottom line, it's what you would expect. Legal spouses and children are at the top of the heap. Next in line would be if you have children of deceased children. So that means like grandbabies through a deceased parent, they would get included. Then it goes up to parents, then it goes out to siblings, then it goes down to children of deceased siblings, goes back up to grandparents, and then deceased. Yeah, I have a whole YMCA thing that I can do. Then it goes down to living people that came from those deceased grandparents. Interestingly enough, it doesn't go as far as great grandparents. Don't know why, but usually you can find somebody who's alive and has the right to take the property. They may or may not have ever met the deceased person, but state of Tennessee says that's who gets it if you don't have a will. Now, that is the crux of what we're talking about here, includes only probate property. And this is a fundamental, really important distinction. If you die and you own something with another person, so for example, the deed to my house, it's got my husband's name on it. It's me and my husband. When I die, my husband already owns the house. He doesn't need a court order to tell him he owns it. He's got a deed that says he owns it. Our joint bank accounts, same way. This isn't just spouses. It can be with children or with others that you jointly own the asset. Our cars, same way. So those would not be probate property and would not go through the court system, or you wouldn't have to look at a will to decide who gets it because you already own it. A slightly different example would be any asset that has a direct beneficiary attached to it. So the most common examples would be life insurance. So, you know, when you bought your life insurance policy, they probably had you fill out the paperwork for your beneficiaries. Well, when you die, they don't need a court order for that. As long as you name someone as your beneficiary, that's who they're going to pay. And they don't care about what your will says or whether you even have a will. Retirement accounts, same thing. You know, you name somebody as the beneficiary of your retirement account, your employer doesn't care what your will says, doesn't need a court order. So those would just pass outside of probate because they are non-probate property. But what happens if you forget to name someone? You don't fill out the paperwork, or the person you named is dead and you didn't name a backup. That's when it will default to us, because they'll say you don't have a named beneficiary anymore. So that has to go through probate. We have to know whether you have a will or not, and we're only going to pay it to the person who can prove they've been appointed as the personal representative of the estate. I use the kind of generic terminology personal representative because that includes all kinds of personal representatives for an estate. So it can be an executor or an administrator. Those are the terms used, but that just means a personal representative of an estate. Okay, so back to the types of cases we handle. Let's see. We've talked about conservatorships. We talked about estates. You'll see some categories here: small estate and muniment of title estate. Those are still deceased people's estates. They just are different categories of them because of either the type of property or the value of it. So small estates can be done if the total probate property is $50,000 or less. And it's just a little bit of a simpler process. It's cheaper to do as far as your court costs. Many of our people who do small estates are pro se, meaning they don't have a lawyer. And in the clerk's office, we have forms that they can fill out. This is hugely important to people who can't afford a lawyer. Okay. You know, we're kind of spoiled a little bit. We take for granted that if we need legal services, we can go get them. But for your average citizen who has someone die and there's a couple $1,000s in the bank, or a truck that they need for work, there is no way that they have access to the same lawyers that a lot of us do. And so I'm really, really proud of what we can do with small estates, because by providing the form, by helping them fill out the form, it's not legal advice, it's just helping them fill out the form, by providing space for them on our dockets to get them taken care of quickly, we're doing a real service for the public. And it's heartwarming. I'll tell a little story. We had, I think this was Tuesday or Wednesday of this week, we got a call from the clerk's office that says, we've got a couple down here. It's mom and dad. Their son has just died. All he has is an apartment, but they need to get in there to, so they need to clean out his apartment, look and try to find out, did he have a will? They don't think he does. They need clothes to bury him in. Think about that, and this couple had come from Florida. They brought mom and dad up with the paperwork filled out. The mom, she had tears the whole time. The mom just had tears going down. This was the worst day of her life, except maybe the day she found out her son had died. And, it's one of the proudest things we do is to help those people get something done they need to do without it costing them an arm and a leg. It's just kind of a different kind of case. But anyway, those are small dollar kind of estates. Minimum of title are ones where there's only real estate. So no money in the estate, but there's a house. And you got to have something with a judge's signature on it that can be recorded in the Register of Deeds office to show who inherited the house. That's what a minimum of title probate is. An administrator ad litem case are those where there's typically no money, there's no property, but a family member, or it could be someone else, but typically it's a family member, comes in to ask for permission to act for the estate for purposes of filing a lawsuit. So these are typically your car wreck cases where somebody died. Okay. So they have to go through us to get that authority. And of course we decide, there's a statute that talks about kind of the priority and pecking order of who has the right to be appointed. So we have to make sure that they're of the right family relationship and make sure there's no dispute. Let's see, there's some things we don't do quite as often, but I did list them here. We have trust cases where, for example, people will say, well, if I have a trust, we don't go through probate on a trust, which in general is very true. Okay. But if you need a court-approved modification to the trust, you have to go through me. I take that back. You can also go through Chancery Court. On trusts, we have concurrent jurisdiction with Chancery Court. If you need a new trustee appointed and your document has run out of trustees and doesn't give you a roadmap on who's authorized to appoint a new trustee, that goes through us. If you need an interpretation of the trust document, maybe the wording is confusing and you're the trustee and you don't know, what that means, you can go through us to try to get an interpretation. So we see quite a few trust cases, but not nearly the volume of cases as we do with wills and deceased folks in the probate estate. This next category is one that I really enjoy doing, which are the name changes. You kind of think, well, what does changing your name have to do with probate court? I don't know. That's just, they tell us that's something we're authorized to do. So if you want a legal name change, you can go one of two places: Chancery Court, and we have 4 chancellors in Davidson County, or you can go to probate court, which is me, and you fill out paperwork. Again, we provide that in the clerk's office, and you essentially say what your legal name is now, what you want it to be, and you have to state that you're not a felon, that you're not doing this to avoid your creditors, you're not doing it for an unlawful purpose, you're not trying to mislead the public. And most people who come before us can meet those criteria. And of course, they have to show some documentation, their driver's license, birth certificate, passport, if they have it, so that we know that's actually the person who is the correct person. So we do those. The most common scenario would be LGBT name changes for transgendered folks. We do individuals who maybe want to take their step parents' last name. They'll say, this is the man who raised me, so I want his last name now, and they're adults. And so if you want it, honey, I'm going to give it to you in that scenario. Sometimes we get women that want to get their maiden name back after divorce, but they didn't get it during the divorce because they wanted their kid's name to match their name. But now their kids are grown and they're like, why am I hanging on to his name? So they'll come ask me for that. I'm like, sure, yeah, that's fine. Just don't be a felon, be trying to avoid your creditors, etc. And then every once in a while, we get someone who changes their name for safety reasons. Maybe they're being stalked. Maybe, there's a reason that they feel unsafe and they want to take their easily identifiable name and make it Smith or Jones or, something of that nature. So we do some of those too. One of the things that we've really embraced in our court is trying to be accessible to everyone who needs us or wants to see what we do. So if you are able to get the paper, you will see there is a link, and that takes you to the Circuit Court Clerk's website, which has the Zoom code that we use every day in probate court. So we don't just selectively use Zoom. We have if there is any time we're conducting court out in that room, I'm pointing to the door back there, we turn on our Zoom whether we have any participants or not, because I encourage people who want to see what we do to just take a look. It's an open forum. You're a member of the public. I encourage law students to watch us. I teach at the National School of Law. So I say, look, if you want to learn how the sausage is really made, just watch. We have law clerks that are in the building. I say, if you got any free time, just tune us in. And so anyone who's interested in knowing what's going on here and how we do things and how we treat people, I just say, look, we're open for business. We're accessible. You don't have to turn your camera on. You don't have to unmute yourself. Just watch, because you're welcome to do that. So we do keep that on and give the option of our participants to either participate, like if it's actually you're in the case, then you have the option to come in person or to use the Zoom. And if it's not a controversial case, oftentimes the lawyers and the litigants will be on Zoom. If it's a trial and there's going to be testimony and documents passed around and so forth, we do encourage you to come in person. But think about the cost barriers. We talk about access to justice. Just simply taking off a day of work, coming to downtown Nashville in our traffic, paying to use our parking garage, which is not free. I mean, that's astounding. If you want to talk to your Metro leadership, talk to them about how, if you're using the services of the Metro courthouse, you should be able to park for free. Because we don't have that here. There's no free parking. There is at there is at the Howard School building. There is at the post office. There are at the libraries, but somehow not to use the courts in downtown Nashville, which, you can easily pay $30 to be here. So I just think if we don't want there to be any unnecessary cost barriers to being able to attend court and know what happened in your case. So that's another reason I get on my high horse about how much I love the Zoom and how important it is using it in our courtroom. So there are lots of other details I could just go on and on about, but I think I've started to see some questions in the chat.
Do you want to take those questions, or would you
I'd
like
love
me to?
Well, would you mind repeating the questions?
Okay.
And then I'll try to answer them.
Okay. Let's see. I will get to them. And the first one, what are the pros and cons for putting your home in a will? There's a very general question.
Yeah. So, well, in a will or a trust, the question might have meant putting in a trust,
Yeah.
But I'll address it either way.
Okay.
Having a will is a no-brainer no matter who you are, right? I'm always going to advocate in favor of you making your own decision about who gets your property rather than the state making that for you, because there are so many intricate little rules about intestate succession that the average Joe is not aware of. And even, let's be honest here, even the average lawyer is not aware of a lot of these nuances and rules. And so I personally would not want to take the risk of it going somewhere I don't want it to go. So I'm always going to advocate in favor of doing a will. But here's what I think the question is getting to is, what if I have my house owned by a revocable living trust? Right? So sometimes they're called living trust, sometimes they're called revocable trust, sometimes they're called revocable living trust, but they're essentially the same animal, which is I want to still control my property during my lifetime, but at my death, I don't want the probate court to have any involvement with it. That would be putting it in a living trust, which is, I think, a great idea to do as long as you really have confidence in the person you've selected as trustee and you think they don't need any oversight. And as long as the folks you lay out as beneficiaries, you anticipate that they're going to be with the program and get along and respect the trustee's role. The downside of having your house or any other property for that matter owned in a living trust is that when you need intervention of the court, when you need us to be mom, and say, hey, cut that crap out, like you're doing wrong. And so we're going to correct you. When you need us, it's a lot easier to access us if you're operating through a will and a probate estate. But lots of people have trusts that own their houses. It doesn't prevent you from selling your house, borrowing against your house. A living trust is one that allows you basically all the same access and freedoms you would have with sole ownership without a trust. But it just means when you die, it goes, your trustee has the authority to go ahead and handle it through the trust and doesn't have to go through probate court. So it's an okay thing. One caution I would give there, though, is people sometimes have the conception, or maybe they've heard through the grapevine that, oh, well, if I have a trust, then that means my creditors can't get it, right? Or TennCare can't get it, or, all the things. That's not true. Your assets that you put in a revocable living trust, while they're not probate assets, they are still not protected from your creditors. They're treated for creditor purposes the exact same as if you would own them in your individual name. So two good options. It's just sort of, which one is more comfortable for you considering your family situation and the ability of your trustee and beneficiaries to carry on without needing me.
So there's a couple of other questions about trusts here. So why don't I ask that one? One is the trust is established in one jurisdiction, but the designated trustee lives in another jurisdiction. Could the trustee bring issues to you if clarification or change of trustee is needed?
Yes. Trusts are designed to travel, right? So if you establish a trust in Florida, but it has property in Tennessee, or it has a trustee living in Tennessee, then, and there are some nuances of the rules for when we can assert jurisdiction, but we are often able to entertain an action filed in our court, even if the trust has some contacts with other states. Either the trust was established there, has beneficiaries there, or property there. Usually if you can find some connection with Tennessee, we're able to take it.
One last question, or another question, has to do with trust, an executor of a trust, and specifically whether someone has to have any legal status as an American citizen if they're part of a trust.
Oh, that is so interesting. Honestly, don't know that I've ever had that issue come up. And I've been doing trust for a lot of years. As a practical matter, you're not going to probably select
A non-citizen?
yeah, well, you know, here's the key. When an individual creates their own trust, they have the right to choose anybody at all they want to be the trustee of the trust. So that would include non-US citizens if I, as the person who created the trust, was the one making the selection. But if there's no trustee and we have to fill that role and it comes before the court, that's what I haven't seen. You know, is any sort of objection based upon someone's status as a citizen or not. So I don't want to answer that one definitively, because that's one that I think would need a little bit of study to see if there's any prohibition. There are grounds upon which I cannot appoint someone as a trustee if I'm doing the appointing. I can't appoint a felon. I can't appoint someone who spent time in the penitentiary. Those are, one of those bits of rights that when you have a felony on your record, there's just certain things that you're not allowed to do. And so that would put a restriction on me if I was doing the choosing. But if the owner of the property who created the trust was doing the choosing, they're allowed to choose anybody they want because it's their stuff.
Thanks. Oh, okay. So you can't appoint someone who's an ex-felon at all?
No, I can't do it in the executor role, as a conservator, as a guardian. Oh, we didn't talk about guardianships. I need to mention that. Okay. We'll get back to the questions in just a moment, but I skipped over guardianships. Guardianships are a supervised process for minors who have money coming to them. So we've got a good number of cases in our court who are, they're minors under guardianship, and the guardian is managing money for them. And how that comes up is we have people who die. Their will doesn't provide for establishing trust for the minors. And then in order to make the distribution of the bequest to the minor, we have to have a guardianship set up in our court. So again, we can supervise, what did they pull in? How are they spending the money? And then when they need permission to do kind of more unusual things, like, I don't know, maybe they want to make a big withdrawal for, fancy private school tuition or something, they might come to us to ask for permission to do that. They don't always, but yeah, so we do guardianships as well. And now I forget what the question was.
You mean the question about guardianship, or the fact that you mean one of the things that we were discussing was whether you can sign someone as a trustee if they are a felon, and the answer is no. And
Yes.
The reason guardianship came up is you can't do that with a guardian either.
Correct. Yep. So I'm restricted. So if mom comes to me and says, hey, I want to handle my little girl's money that she just inherited from her grandfather, and I ask her those questions about, has she had a felony? I can't let her handle that money. I just can't.
All of the, things that one finishes with, go through prison or fines and all that. It doesn't matter. Just having had a felony.
Yeah.
Okay.
Yeah. And that's by statute. And it's frustrating a little bit, because every once in a while there's a case where the most qualified person in this family's existence might actually be somebody who has an old felony, right? I mean, let's say in a conservatorship, there's one child, and she had a felony from the 70s. Yeah. And all she wants to do is take care of her mom. She wants to be able to take her to the doctor. There's no money. She just wants to be able to talk to the doctor, deal with the medications and the healthcare workers and so forth. You know, it is a bit frustrating on our end that the statute restricts us so tightly.
Yeah.
But that's what the law provides. So.
Okay, I think that's the trusted stuff. There are a couple of questions about name changes. In particular, you were describing people changing their name for safety reasons. A couple of us have assumed that you don't have that on Zoom and that you don't make that public. Or
Well,
in those situations.
yeah, that is such a good question. We don't make any distinction about the Zoom or not. So, you know, in order to close the courtroom, which means cause us to turn off our Zoom and literally lock the door and keep anybody else from the public out, it is an extremely high standard that would have to be met to close a courtroom. Okay. But it's a lesser standard that has to be met for sealing of a record. So what we will do, and I'm so glad you brought this up, when there is a safety concern, you know, the folks are typically representing themselves without a lawyer. So we try not to practice law for them, but we do sometimes hint a little bit. So let's say, you know, woman comes in and she's like, my ex-husband is stalking me and he's made these death threats and I have this protective order and I'm scared and I want my last name to be Jones. Please, judge, can I, you know, would you help me do this? We would still have our Zoom on because she'd be on a regular docket, you know, like everybody else. But what I might say to her is, well, all right, would you like to make a motion with the court to have your file sealed? And she'll say, yes, absolutely. I'd like to make a motion to have my file sealed. And I say, all right, well, you know, you've given me testimony under oath of the reasons why that would be appropriate. And so I'll do it. You know, I think some cases are not the public's business, but you know, I can't make that across the board for everybody because we have open, transparent courts. But in the right set of circumstances, and if you meet the standard for sealing the file or sealing, some people will ask to seal an entire file. Some people will ask just to seal certain sensitive documents in a file. Here's a great example. In conservatorships, we have reports of physicians that have very sensitive medical information. I mean, think about that. Would you like for your medical file to be, you know, in a court somewhere so that all your nosy neighbors could read it? No, I wouldn't either. So we seal those. But we don't seal the entire conservatorship file because, again, we need transparency and oversight. But if it has your sensitive health or financial information in that document, we will oftentimes seal just those documents so that I can see them, my court officers can see them, but the general public, if they came in to ask, well, I want to see a copy of, you know, the medical report for my neighbor, they would not have access to see that. And we do also seal, or we redact certain things like account numbers. We'll black them out so that you can only see the last 4 digits, social security numbers, dates of birth, identifying information that could be used by identity theft people or for fraudulent purposes. The clerk's office is a big part in making sure those things get redacted upon entry.
So one of the questions also is about that conservatorship that you mentioned, and that is if you want to predetermine, like, you know, something happens to you, can you set up something so that you don't have to go through the court? So that, say, if something happens to me, is that like a living will? Is that what that is, or something like that?
You're close. You're close. The best way to avoid needing a conservatorship in the first place is by executing a valid, durable power of attorney.
I see.
Okay. So a power of attorney basically says, I'm alive. I'm competent to decide who I want to be making decisions for me if I am still living, but I become incompetent. So I'm going to probably pick my husband, my daughter, my best friend, maybe my mama, you know, but that would be the place where you can decide who has that authority, because then when I have my, my medical event that puts me out for a while, then the person named in my power of attorney can just use that document to talk to my doctors, talk to my bank, talk to my employer, and wouldn't even need to come to court to seek a conservatorship. So conservatorships are kind of the last alternative that you turn to when there's no other place you can find the legal authority, or, and this is important, if someone has legal authority but is abusing it. Okay? I mean, who in their family has not had sort of a turd in the punch bowl of someone in the family who has taken a power of attorney and used it for evil? They've helped themselves. They've given gifts to themselves and their kids, but not brother and sister, right? Or maybe they're not treating mom right, or, maybe they change beneficiaries on mom's account. That was sneaky. Well, that's an abuse. That is elder abuse, and that is abuse of a power of attorney. So you might think, if you're the sibling, well, what can I even do about this? What you can do is you can go to probate court. You can seek to be appointed the conservator for mom. And you can say, by the way, my sister who has power of attorney, she's abusing it. And I want you to, judge, I want you to revoke her power of attorney, require her to show what she's done, or appoint me as conservator so that I can go to the bank and I can pull the records and I can show you what she's done and you can enter a judgment against her. I mean, conservatorships are sometimes the remedy when you have a power of attorney gone wrong and you essentially need to have family litigation when someone's still alive. It's kind of, in a way, sometimes it's sort of a pre-will contest, right? Like they're fighting about the money even before mama's dead, but it's not just about who gets it when mama dies. It's about making sure there's enough there to take care of mama. Because if you spend it and you abuse it and you leave mama on the doorstep, who's going to pay for her care? Who's going to pay her mortgage? So there are some cases that are shocking and sad and pitiful and disappointing, but they exist, they're out there. And so we're here to kind of help stop the bleeding and help put the pieces back together if they can be put back together.
So we do have a question about handwritten wills. Do they need to be witnessed or notarized?
No. So handwritten wills, also called holographic wills.
Oh, nice.
Yeah, that's a big word. So holographic wills, we see a decent amount. In terms of the requirements for them to be legal in Tennessee, it doesn't take much. They need to have all material provisions in the handwriting of the testator, which is, the person making your will, and they need to be signed. So if I literally pulled out, this notepad, I wrote one paragraph, I signed it, and it showed testamentary intent, and it was proven after I'm dead that this is all in my handwriting, it would most likely be treated as a will, even though there are no witnesses, there's no notary, there's no pomp and circumstance. So you might think, well, wow, that is so simple. I'm just going to do me a holographic will. I beg of you, I plead of you, please, please, please do not do this. And here's why. Even though it may be a valid will in Tennessee, even the smartest person in this Zoom room will screw it up, because they always do. There's always something about it that they haven't thought about, or they've worded in a strange way, or they forgot to include, or they maybe say something in there that makes perfect sense now, but 5 years from now when you die, it's just a mess because the circumstances have changed. And in a proper lawyer drawn will, it provides for all those contingencies. Okay, so I think I see people in here that come in with wills they've done themselves, whether it's, a typed up kind or a holographic handwritten kind. And for the amount of time and trouble and money that you have to spend trying to fix the problem after the fact and clean up the mess, oh my goodness, you should have just spent that $500 or that $1,000 or whatever it is to go to a lawyer and get a proper will done in the first place. I mean, it's just, I just think sometimes these folks must be looking down or up laughing at their family about how much trouble they've caused them by trying to do their own will.
And it's
So
great for, movies and novels and fiction and things like that, as well as I'm sure you could probably start writing many of those stories yourself.
oh yeah, it's super fun and dramatic. I mean, they're the fun ones to read, right? I had one this week that it was this person had a holographic will that went into great detail about all the things he wanted, including he wanted, I hope I get this right, he wanted a green sport jacket. Right? He didn't want to be embalmed. He wanted to be buried a certain place. He wanted a green sport jacket, a green shirt, green slacks. He used the word slacks, not pants. And then he said green shorts, which I assume that maybe meant underwear. I'm not sure.
Yeah, I
And I think there may be even like green shoes and socks. I don't know what the obsession with green was. But the handwritten wills are super entertaining. But this one had problems. The actual carrying out of giving property to others in this hand or homemade will was messed up. And, lawyers, I think this may be about the third time these lawyers have been back trying to clean up this mess. So just, I would please ask, don't do it. But that comes from a lawyer who has written a lot of wills. And so maybe I see the value in that more so than a lot of people, but.
Yeah. So there is also issues about, there's a question here about not just a will, but if you have a deed to your house, basically, can you place someone in that in succession for the deed, like as a tenant in common or with rights of survivorship or any of that? And do you have to do that? Can you do that without going through a lawyer, or do you have to go through a lawyer for that kind of thing?
Yeah. Well, when you are, the deed to your house is essentially your ownership label, right? It's what shows who owns it. So however you want that to read, or however you want it owned is how you'd want it to read. So it could be, I'll do Carol and I. We could on the deed say that we each own 50-50, a tenant in common interest. We could say we are joint tenants with right of survivorship.
I see.
If you see that phrase on a deed where it says with right of survivorship, that means when one owner dies, the other owner just gets it. And you don't need a court order. You don't need a new deed. Because if Carol and I owned my house with joint tenants with right of survivorship and I die first, Carol doesn't have to go to probate court. She doesn't even have to file anything new. But when she wants to sell our house, she would just show my death certificate and her deed. And that is what establishes her authority to sell the house. Now, if you want to get real fancy and have multiple owners, like, hey, I want to put all my kids on my house, because I know that's what you're thinking. That's what everybody's thinking right now, that I could avoid legal fees and go into court by just putting all my kids on my house. I'm going to give you a little caution on that, because once you make them owners of a piece of property, your house is now subject to their creditors. Okay. So when your son, who's on the deed to your house, he didn't pay for it. He didn't pay for the mortgage. You just thought, well, this is great. I'll put him on my house so that when I die, he'll just get it. Well, when your son is filing for divorce and your daughter-in-law says, well, I want my half of his part of your house. So you just kind of have to be careful about that kind of thing. Deeds, you are certainly allowed to draw up a deed yourself. Again, I would never advise it for the same reasons I would never advise doing your own will. But keep in mind, deeds are not expensive documents at all. If you go to a title company and say, hey, look, this is, I want to make a change to the deed of my house. They can draw that up for you pretty inexpensively. Or just a regular lawyer can do that. It's not a big involved process, but think about, why you want to do it and what's the end game. And are you willing to risk the consequences if something goes wrong in the meantime, such as the person you put on there having creditors or, God forbid, a bankruptcy. Because a bankruptcy trustee, it has no mercy. The bankruptcy trustee's job is to try to find and collect anything they possibly can to pay creditors. So
interesting.
I'd be careful about that.
I will say that there are many, many questions, and we are getting to the end of the hour. So I don't want to keep you. And I think increasingly, I mean, I think this is why you love doing this, A, and B, why it was incredibly easy to talk with you, and C, why everyone else wants to ask you these questions. So one of the things that I'm just going to mention to people is that one of the things that you talked to me about, which I thought was amazing, was your idea about the office being an educational thing as well, going to churches, to all sorts of places. Are you continuing to do that?
Yeah.
And
yeah.
you have a list of events that you're speaking or your office is speaking at?
What we have done, I don't have an official list, but as you can imagine, after 19 years of the same judge that everyone knew well and they knew exactly what to expect from him, once you get some fresh meat, people kind of want to know, oh my gosh, who is she? What's she going to do? Is she going to be a raving lunatic? You know, what are her changes going to be in terms of compared to the way that, you know, we've all known and loved it for all these years. And so as soon as we took office, which, by the way, today is our 1-year anniversary of taking office. So this is actually a very cool day for us. We made it 1 year. But we got a lot of speaking requests. And so I've just been doing all of them that I can. Many of them have been to lawyer groups through the Nashville Bar Association, the Tennessee Bar Association. Particularly, I've done a couple of them for just younger lawyers. Because they're the ones that are trainable. You know, if you get them young and early, you get a chance to teach them what you want and how to do it right and how to shine, because that's really what I want them to do. I want them to do such a superior job for their client that they look great and the client's happy, right? And I get what I want, which is compliance with the statutes, you know, and I don't have to call them out in front of everybody else because, you know, I just wanted to do right. That's all. But anyway, so it's really been kind of a year-long process of trying to reach the goals that we set and trying to get the word out. And we're, you know, doing more and more of that as we go along. I think in this second year of our time, we're going to be able to transition a little more to the public and less to the lawyers, because we've got our lawyers trained up pretty good. You know, we have good lawyers that come to our court and they're repetitive. They come over and over again. So they're now with the program.
Fantastic.
And, but, you know, don't be surprised. Look, I'm shy. I know this doesn't seem like it, but I really am a shy person. But unless we're talking about probate or dogs or tomatoes or bikes or East Nashville, then I'll say anything you want, right? I'm always willing to talk about those topics. But you may see from time to time things with like the Kiwanis or the, you know, just kind of civic groups that just want to have these discussions. And so we'll be probably doing more of those.
Well, this is fantastic. Thank you again so much. And also for your dog who came popping in and out.
Is Archie in here?
Yeah. Well,
he may have left.
Right. He came in for a moment and I think he shook. So we have a little shaking on the whatever. Also, I want to remind everyone that we meet every first Friday of every month. And so the next one is October 6th on alternatives to the death penalty. And also the file that you recommend, that you referenced, that people may want, you should send me, there he is again. Hi.
Oh, yeah, Archie.
And you should send me a request at my email that I sent in the chat, and also it will be uploaded to the website with the hot topic to the hot topics area. Hey, Archie.
Yes, this is Archie. So what I want to show you is his prized possession here. He has a name tag with he's a certified court officer for the probate court, with his picture, with his stats on it. That was something that our security guards made for him as a little gift.
This has been just a joy. Thank you so much.
You're
Just
welcome. I'm glad to do it.
forward to you being able to seeing you out and about. So thank you again. And thank you for everyone who showed up today. We really appreciate it. So thanks again.
Okay. Bye-bye, guys.
Bye-bye.